Now, after a 13-year trial, Shell Nigeria was on January the 29th ordered by a Dutch court to compensate for Nigerian farmers for major oil spills the farmers say caused harmful pollution to their lands. Shell had previously denied liability, blaming the spills on sabotage and claiming that the cleanup has been carried out satisfactorily. By the ruling, Shell Nigeria must compensate the farmers for the losses they suffered due to the oil spills in the two villages of Gol and Uruma in 2004 and 2005. The case only started to make serious headway in 2015 after the Hague Appeals Court ruled that Dutch courts had jurisdiction over the case, 7 years after the farmers first brought their case forward. Now, a major highlight in the case this case is that Royal Dutch Shell breached its duty of care by not doing enough in response to the oil spills. This is the first time that a parent company has been held responsible for acts of its foreign subsidiary. To give us some insight into the ruling and associated matters, we have the Acting Executive Director of the Environmental Rights Action, Barrister Chima Williams. He will bring us more. He will be talking to us about this development. Thank you for joining us on TVC Breakfast.
Thank you very much for having me.
Now, after 13 years of battling for justice, the farmers finally won. Now, tell us what is the significance of this ruling against Shell?
Well, the significance of this ruling, this judgment, because it's no longer a ruling,
it's a judgment, right,
of the Court of Appeal in The Hague against Shell are numerous. First is that it has shown that the complaints of the victims are adjudged to have been genuine one. And Shell had been negligent, in management of the complaints and, of course, the impact of their activities on the victims and other parts of the Niger Delta. Thirdly is that this judgment clears the pathway for any other impacted victim, either community or individuals, to seek redress, okay? Because there are a lot of landmark pronouncements that are made by that judgment, one of which is the issue of the position of EGASPIN, Environmental Guidelines and Standards in Oil Production, wherever in Nigeria, which is a regulatory mechanism put in place by the operators themselves to guide them. It's a guideline, okay, to guide them, which the operators have on their own elevated to the status of law, which is not. Because EGASPIN, as we've always argued, and we argued this before the court, the Dutch court, has not passed through the legislative processes to become a law, okay, that will be binding on everybody. And the oil industry players lashes on EGASPIN because it states that where there is a third-party interference, okay, they are not liable to compensate the victims, but they are liable to clean up and remediate the environment. So, but this judgment has clearly put to pay that it is not a law. And secondly, the issue of always rushing to claim third-party interference, okay, which is called sabotage.
Yes.
We equally have been arguing that sabotage is known to our criminal law.
Right.
And is covered by criminal law provisions, criminal act provisions. And therefore, sabotage on its own is a crime. It's not a civil offense. It's a criminal offense. And if it is a criminal offense, it means that you have to prove it. Not just merely alleging. Okay, you prove it. And the standard of proof in criminal proceedings is beyond reasonable doubt. And one step to proving this is that the companies that are alleging sabotage should have presented
evidence.
The suspect first. Okay? If you present a suspect, that suspect will pass through the rigors of trial and be convicted for committing that act before you can now latch on it to exculpate yourself. These the companies are not doing. They stay in their cozy offices. You know, once they hear there is a spill, first statement is that it's sabotage before any form of investigation is conducted. And after conducting such investigations where they discover that it was as a result of mismanagement of their facilities or the disruption that occurs as a result of the age of their facilities, because most of their pipelines are obsolete. They have outlived their lifespans. Okay, so when it gets in, they say it's sabotage. When it is equipment
so invariably, you're saying that there is no, we have to rule out any case of sabotage in this matters.
That is what the court have said.
Right.
And although for me, I equally won, because, you know, this ruling, this judgment have said in sabotage cases you must prove beyond reasonable doubt. It is not a license for anybody to go and commit destruction of facilities. That you'll be working against yourself, working against your community, and working against the Nigerian state. So
in all of this, we can say that justice has been done and been seen to be done with this judgment. Is that what it is? Yeah,
with this judgment, justice is seen, manifestly seen, to have been given.
Right.
But it is when it is executed that we now see it being done.
All right. Now, tell us what the specifics of this case are, especially why the farmers had to seek justice in Netherlands.
Yes, this is a question that I receive all the time. Why support, you know, Nigerian victims to seek court attention elsewhere? And I've always been very clear about it. The reason is very simple. It is not because I do not have confidence in the Nigerian judicial system. I have absolute confidence in Nigerian judicial system as a lawyer, because I have secured judgments that set standards from Nigerian courts. Okay? But the problem is, when you secure a favorable judgment, what do you do with it? The implementation of the judgment or judgment orders are not by the courts now. It goes back to the executive. And the executive in Nigerian situation must have joint venture arrangements with the oil companies. So implementation and execution of judgments against oil companies in Nigeria becomes difficult. Okay? And this is why most of these multinationals, when you secure judgment against them, instead of abiding by the dictates of that judgment, they set their own standards, including renegotiating the terms of judgment that have been pronounced. And a key example, okay, is the case of, I think it's Ejame Bubu, you know, where the case has gone up to Supreme Court. And the Supreme Court has made a pronouncement in favor of the victims. Now, rather than Shell implementing the decision of the court, Shell is today dragging Nigerian state before World Bank Arbitration Panel. Does that not subvert the sovereignty of Nigeria? Because the Supreme Court is the apex court. And for us as lawyers, when the Supreme Court has made a pronouncement,
it's final.
The only appeal you have to is to God, except through a legislative action by the National Assembly, properly constituted, reverses that. Okay, so when Shell now takes the case of individual Nigerian victims to now go against the corporate entity of Nigeria, for us it becomes troublesome and worrisome.
All right, let's break down this 13-year battle, how it was made possible. Especially, let's look at the role of the environmental rights action, the role they played in the whole case for 13 years.
Well, Environmental Rights Action Friends of the Earth Nigeria has as its philosophy protecting the environment, democratizing development. And this we do through, working with victims against any form of environmental destruction. We don't care who is responsible for that, be it an individual, be it the state, be it corporations. So long as you are destroying the environment, you have problems with Environmental Rights Action Friends of the Earth Nigeria. And it was in this case that the victims of these pollutions, because every day we receive complaints from victims of one form of environmental despoliation or the other, either by companies, by citizens, by governments, by whatever authority, companies, both local, national, and international. Okay, so, but when we receive such complaints, we investigate. Because we want to be sure that the complaints that we've received are real, they are genuine, okay? And it is actually caused by those that fingers are pointed at. So it wouldn't be a matter of Mr. Paul committing environmental despoliation and then you are going after Mr. Peter. Okay, so we do that. When we received these complaints, we did those checks, okay, and then convinced ourselves that the complaints are genuine. And we reached out to our sister organization, Milieu Defensive Friends of the Earth Netherlands, and we're able to explain to them, to their own acceptance and understanding of the situation. And this is why they are equally co-claimants with the Nigerian victims. Okay, so with this, we started a cooperation between ERA and Milieu Defensive to support these victims. And in that, we have to provide the legal background from the Nigerian perspective, because as the case goes to the Dutch court, it is a mixture of the laws of Nigeria and the laws of Netherlands, that will operate.
Yeah.
Now, personal, private property law relating to Nigerian legal system, and then procedural law relating to the Dutch legal system. So this mix we had to bring to bear, working with both our sister organization and the team of lawyers, from Netherlands. So we provided the bridge, because through Environmental Rights Action Friends of the Earth Nigeria, the victims got to meet and associate with Milieu Defensive Friends of the Earth Netherlands and the lawyers in Netherlands. So this, we continued to enlighten the community people, first and foremost, on the need to seek redress using the instruments of the law rather than seeking redress through self-help. And this is our cardinal principle, to ensure that people do not suffer double jeopardy.
Absolutely.
Okay? Because when your environment is despoiled, if you seek self-help, the multinationals will call on the state security apparatus to come and quell whatever you are doing. And in that scenario, Nigerian soldiers or Nigerian police is drafted in, those that they attack are Nigerians. Those that are doing the attacking are Nigerians.
Right.
The soldiers, the police, the victims and community people, we are all Nigerians. So at the end of the day, whatever happens, it is Nigeria that is losing.
At the end of the day, right.
All round.
Okay.
But the multinationals will take the profits to their home countries.
All right. For want of time, we have to move quickly because there are some issues we also have to delve into. So this next question has to do with the fact that ruling has not been made in one of the cases, and that there are rumors that Shell has reached out to the community to stave off the case, going as far as ruling that warrant paying compensation or something. Is that true?
Well, it is true because it's no longer secret that Shell lawyer had reached our lead lawyer.
All right.
And we are in communication, to discuss whether to accept, negotiation. Okay. Pending the ruling of the court in the case of Friday Akpan against Shell. Friday Akpan is from Ikot Adaudo community in Akwa Ibom State. And he had won his case at the lower court. Shell appealed against the judgment of the lower court at the Court of Appeal. The distinction is that the judgment that was delivered was on the cases that we lost at the lower court, which we appealed to the Court of Appeal. So there are two appeals. Right. And two different cases. So, in the case of Friday Akpan, the judgment had not been delivered, but the court had asked for further information to enable it decide which way to go on it, on their own judgment. So, Shell lawyers have approached our lawyers. That is correct. Okay. But we are still in discussions.
All right. During the ruling or the judgment, there was no amount decided with regards to compensation for the farmers. At this point, as of now, do we know, and are there modalities in place to ensure that these farmers are compensated?
Well, you see, this is the jurisdictional differences, jurisprudential differences. In the Dutch judicial system, in a claim like this, you do not put compensation amount. The court has to first agree with you that you are entitled to compensation, and then you move to the next stage of either the parties negotiating the compensation terms and then coming up with an agreement, or coming before the court to present what you consider what you need as compensation, and the court making a decision on it. So as it stands today, Shell has not reached out to us concerning the two cases that we just won on the 29th of January, because Shell still has the right of appeal. There is still the Supreme Court of Netherlands where they can still appeal to if they don't want to resolve the issues. So for us, we are waiting to see what steps Shell wants to take, whether to discuss and negotiate and settle, to shorten the time, or they want to go on appeal to the Supreme Court. Whichever one that they want to do, we are ready.
Right. Now, so what are the lessons for the impacted or for other impacted communities in the Niger Delta? Although we are short of time, but quickly before we run out.
Quickly, let me point out one good part of this judgment is that the court had ordered Shell to put leak detection systems on their facilities to ensure that once there is a spill that wants to occur, they are notified to shorten the spread.
All right.
Now, the beauty of this judgment and how the other communities in the Niger Delta can relate with it is that it has provided an opportunity and an avenue for them to seek redress for the destruction of their environment from the company anywhere in the world, because the UK Supreme Court decision has equally given open space for victims to bring cases to the UK.
We have to leave the conversation here now. Acting Executive Director of the Environmental Rights Action, Barrister Chima Williams, thank you for speaking with us.
Thank you very much.